Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey there, everybody. Welcome to another episode of the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer. So glad I can join you and you can join me on the show today. If you are watching us on our YouTube channel, you know you can take us wherever you want to go on whatever fine podcast platforms you get your audio podcast content. If you're listening to us on one of those podcast platforms, go and check us out on our YouTube channel. Hit the subscribe button, leave a like, leave a comment, and most importantly, let your friends and family members' friends all know how much you're enjoying the lunch hour. I am so excited to bring our guest on today. Turns out we have a connection going way, way back, which we hadn't realized before. Our guest today, very excited to bring him on, is Donald Kochan. He is professor of law and executive director of the Law and Economics Center. He is an elected member of the American Law Institute and serves as an advisor to ALI's Restatement of the Law Fourth Property Project. He is at, I should have said this before, the Antonin Scalia Law School. Before that, he was the Parker S. Kennedy Professor of Law at Chapman University's Dale Fowler School of Law. His scholarship focuses on areas of property law, constitutional law, administrative law, all issues near and dear to my heart, local government law, natural resources, environmental law, and of course, law and economics. He has published several books and more than 50 scholarly articles and essays in well-regarded law journals. He received his J.D. from Cornell Law School, where he was the John M. Olin Scholar in Law and Economics and managing editor of the Cornell International Law Journal. And he received his B.A. from Western Michigan University. Professor Kochan, thank you so very much for joining us today.
Thanks so much for having me, Andrew. I'm excited to talk to you.
So let's start here with a general question, because we're going to talk about all kinds of things that you're working on. But let's talk about the importance of property rights and a review that you did. Property is as property does, or is property as property does. What does property do? Talk about the importance of property and what it does.
Sure. So property and property rights are really the grounding of all of our other rights. It is about individual autonomy. It's about the ability to exclude others from your own self, as well as from your physical things that you own. So if you think about that, if this idea of sort of a autonomy over your own decision making is guarded by your individual property in yourself, much like your ability to control your resources and things in the world, that once you own them, you have that ability to control how they are used, how they are disposed, how they are sold, and whether or not you keep or do not keep them, and if you transfer them on what terms. And that really does then give you the incentive to invest in it, because that's really what it's about. It's about giving you the ability to decide to improve your property, and going back to Locke, then the fruits of your labor, you want to be able to keep the fruits of your labor, but only if you can assert property rights in the improvements that you make on the things that you own can you actually have an incentive to do those things in the first place. So all of human progress really requires this ability to incentivize individual behavior, which at our root, at our human nature, really requires that we be able to keep what we own and have a neutral arbiter who will enforce against coercive takings by private individuals as well as by the government.
Yeah, we're gonna get into the issue of takings and regulatory takings. I literally had a conversation yesterday with a woman who was came here from an emigre from Croatia, and we were talking about Central Europe and the nations that were formerly communist and those that have sort of come out of it and prospered, and those that are still struggling. And I talked to her. The two of the most seminal books in my life are The Mystery of Capital by Hernando de Soto and Property and Freedom by Richard Pipes. And it gets distilled down to this idea of property rights. They allow people, as you say, to invest in themselves, to invest in their future. And because they can rely on the law to protect them and that investment, it gives them that hope. It gives them that investment in society in general. So it leads to property rights lead to prosperity, but they also lead to political stability. Talk a little bit about that.
Sure, and DeSoto really does a fabulous job of explaining what happens in the absence of enforceable and identifiable and neutrally arbitratable property rights. And what he focuses on is this idea of needing to paper your property rights and have a recognition of who owns what. If you don't have the ability to actually identify what you own, and there's no way in which the courts can figure out that you own it, then you're going to be subject to, the Hobbesian men and women of the world to just sort of plunder and take everything from you. And so really the political system and political stability is dependent on a way in which individuals have their, control over their own resources so that the government can't come in at any one point in time and disrupt that. So you need confidence, and the political stability provides that confidence, but also the existence of private property provides the stability to the enforceable private property limits the government in a way that provides that kind of stability, but it also limits your fellow citizens because they can't simply plunder without consequence. And what really is important there is that if it all breaks down and there is no rule of law, which is really, at the heart of what DeSoto is talking about and Pildes as well, is that if there is no rule of law to protect property, then people not only won't have an incentive to invest, but they won't be able to get things like loans based on collateral on what they own. They won't. Progress is impeded when individuals can't use the property in the multiple ways that we use it, not just in sort of productive activity, but also in creating wealth and creating collateral for future investment by third parties.
It's amazing. I had a conversation. I know my listeners know this. I tend to talk about recent conversations that I had. I had cause to sit down with a Native American tribal leader. We were at an event a couple of weeks ago, happened to be driving in a van from one venue to another. And I said, I hadn't realized, or it never occurred to me for the longest time, that part of the reason why there is a limited amount of economic success on tribal lands is because you cannot get titled property rights in those lands. And it really is fascinating to me. I mean, I don't know if you've ever done any study on that, and I'm going to make the mistake of asking a question that I don't know the answer to. But I mean, have you ever looked into this? I mean, or given any thoughts? I'm sorry, and I'm going to interrupt myself. And I say this because about 20 years ago, I was on a task force to investigate how to apply these kinds of international thoughts of property rights, this DeSoto viewpoint. We worked a little bit with the Institute for Liberty and Democracy on the international scale in places where the U.S. was trying to develop, fledgling democracies in like the Middle East, and trying to find a way to bridge the gap between local tradition, right? Because you can't take out mortgages, if you're an Islamic country, but there are other ways to do it. I'm sorry. Right. So have you ever given any thought to how, at least in sovereign tribal lands, they might do this here? That your thoughts here?
Sure. I've not done independent research on this, but I have done enough to know that the absence of property rights has led to a lot of directly attributable. But I will point you to some people who I've learned from who are really smart in this area and have done some great work. And one is Terry Anderson at the Hoover Institution, and his program Renewing Indigenous Economies that's being run out there is all focused on this. He does sort of two big projects. One is that he identifies that Native Americans or Indians have in their history been actually very property rights sensitive, and so the historical narrative that we have that there's an absence of property rights in the tradition is wrong. And
then General Custer can certainly attest to that.
Right, and then the second is really that what's kept many of the reservations in poverty and has impeded economic development has been the absence of property rights. The other person that is doing really interesting work in this area is Thomas Stratman, who's my colleague here at George Mason, and he has an index, much like the Economic Freedom Index.
Sure, yes.
He has an Economic Freedom Index that he is putting out or has put out related to tribal lands, and explains exactly that connection that you're saying, which is that in the absence of property rights, they do worse. To the extent you have some mix, they do better, and to the extent you have greater or more robust recognition of property rights on tribal lands, you get even more economic freedom, and that leads to more economic prosperity.
How did you come to be interested in this? I mean, for me, I never thought much about it until I worked for our mutual former colleague, Roger Marzullo. The issue of property rights, and it's funny. I will never forget my mother, very, very skeptical. She's had a political transformation over the years. Very skeptical of me working for this constitutional conservative, doing this kind of work, until she came home one day and found a town-owned bulldozer in their backyard, and called me up frantic, wanting to know what could be done. How did you come to be interested in property rights issues like this?
I think it actually goes back to high school debate and reading a bunch of stuff back there about sort of positive and negative rights. And so it started out with just sort of this understanding of negative rights, or the right to be the freedom from rather than the freedom to. And then reading a lot about the freedom from sort of coercion and where is that grounded led me to do more serious reading in undergrad. And then I had, as one of the great experiences I had in my life was going off and working for a summer as a fellow at Defenders of Property Rights, and really understanding the nature of the threat and the need for more robust work in this area. As soon as I left that, I sent out some stuff to the Mackinac Center for Public Policy.
Nice.
We collaborated while I was in law school on me writing a monograph on reforming the law of takings in Michigan, and so that got me really. That gave me the bug to be doing work in this area generally, and along the way, one of my favorite first projects was mixing law and economics with all of this to understand public choice theory and how interest groups will try to lobby to gain the condemnation power to displace communities because it's cheaper than going through the market to actually acquire the property they need for development. And so there's a lot from law and economics that we learn about interest group behavior in the public use context.
Are you tracking at all the issue of natural asset companies? Are you familiar with this issue? Thankfully, for right now, at least, it's dead and buried. But at one point, the previous administration was talking about empowering the SEC to engage in valuations of things like view sheds and air sheds in order to allow for competitive, I'm going to say bidding is not the right word, but essentially to put these values so that large investment firms could essentially push out resource utilization on the public lands, i.e., we're going to value the airshed or the view shed more than the actual grazing lands or mineral lands. And so if you're going to maximize this use through that, anyway, it's an interesting idea. I'm sorry, it's a dangerous idea, but it's one that might be of great interest to you. But let's talk about the last, I'm going to say 30 years, because you did work with the Marzullos back in the mid-90s, back when property rights were really considered a poor relation in terms of the bundle of rights. There's been a movement, not everywhere we want it to be, but there's been a movement in the right direction in terms of the issue of takings, the issue of regulatory takings. Talk about this, and then we'll talk about whether or not we're mislabeling it. We should call it something else. But talk about how things have changed since the mid-90s.
Yeah, I credit it largely to the growth of the public interest law firms, particularly the Institute for Justice, Pacific Legal Foundation, Washington Legal Foundation, Atlantic Legal Foundation. All these folks really kind of investing in these cases because.
Hold on. Let me just interject here. And I've long told people, including my current research assistant, that this is if I'd gotten my JD, this is the kind of law that I would want to be practicing, because I love the work. I love the work you're doing, obviously, but the work that PLF and IJ do, it's amazing to me. But go ahead, please.
I agree. And what's important about it is, and why you say why this is revolutionary, why there's been a change, is because they're taking cases that no one could have afforded to bring before themselves, right? And so you didn't get as much pushback. And logically, if there's not going to be as much pushback, that also increases the sort of the leverage of the regulators and the leverage of the of others to pressure people into accepting, and they just don't think they have any recourse. And so what I think it's done is it's given hope, but real hope with teeth, and that is that they can actually sue and seek justice. And prevent overreach on the part of the government. And so that's been, I think, the big transformation. The second really is public, and they're related, is just public awareness, right?
Right.
I often tell people that the Kelo case,
Amen. Yes.
was not particularly revolutionary, right? The precedents, if you looked at the precedents going back 50 years, you knew how Kelo was going to come out.
Right.
What was different is social media and the public interest law firms who pushed out the narrative and got people excited and outraged about this. And that in and of itself is a constraint on the window, right? So you can kind of talk about maybe an inverse Overton window.
Sure.
There's less of an opportunity for regulators to push the envelope as a result of the exposure and sunlight that's been provided to these.
Is it my imagination, or are we at the 20th anniversary of Kelo? Was that 05? I mean,
Yes.
that's crazy that it was that long. I mean, oh my God, that's just insane that it was that long ago. But it's so funny you say that, because whenever anybody talks about the importance of stare decisis, I'm like, yeah, but stare decisis gets us decisions like Kelo. So I'm not so sure I'm all there with you. And so many of, we're seeing this playing out in terms of the regulatory world. I mean, we just, the policy work that I do, we just filed comments in the latest iteration of the Waters of the United States investigation, talking about how we now need to really follow Supreme Court precedent. But let's talk about the issue of regulatory takings. Have we mistermed it? Is there a better term for this?
Well, thanks so much for bringing this up. I've been working recently on a variety of linguistic studies. The first was whether or not, why do we call the takings clause the takings clause when it is the takings clause itself, that label takings it's a label which is descriptive of the power that's limited rather than by the right that's protected. And so my first work in this area focused on that, and also discovered, shockingly, that the first time that any court used the label takings clause was in 1954. The first time the Supreme Court ever used the label takings clause was in Penn Central in 1978.
Right.
So there's a whole another story there. On regulatory takings, though, my most recent work is on why we should be calling them involuntary regulatory servitude.
I love it.
Because it mixes up the idea to say that somehow there should be a separate subcategory of takings. It is all about the government is taking a specific interest, much like you could sell it, right? A servitude. You could sell an easement. You could sell a covenant to someone else that said, I won't cut down the tree in my backyard. Your neighbor could come and get an agreement with you and get a servitude that says you'll never cut down the tree because they want the shade, even though you have the right to cut down the tree. They have to pay for that when they buy that little stick in the bundle overall. So what's happening when there's a regulation that accomplishes the same thing, placing a limitation on someone's property, is really creating a servitude, but it's doing so in a coercive manner, an involuntary manner. And so I believe that the better terminology of this should be for involuntary regulatory servitudes. It calls it for what it is, rather than some amorphous thing that allows the courts to somehow distinguish and say that a regulation is not actually affecting property rights if it's only diminishing value.
Right. No, it's an excellent point. And I think you're absolutely correct, is that words have meaning and we need to get very specific in these things. And that it makes perfect sense to me. Listen, I'm someone who, when we think about these things, I'm someone who looks at my mailbox and says, wait a minute, I don't really own the mailbox. I just own the metal around it, but the federal government owns the space inside it. I'm also the weird person who looks at, ads for pharmaceuticals and says, well, we put the ad in, but then you got all this stuff at the end, which takes the time away. So it's weirdly how I think about these things. And I love the idea that it's an involuntary regulatory servitude, because you really are in sort of service to somebody else. Let's fast forward to what's going on in Louisiana, because this is really interesting to me. I mean, I'm always fascinated by sort of Louisiana's approach to the law and how it differs from other states. But what's going on down in Louisiana?
So Louisiana, a number of parishes in Louisiana, it's about 43, I guess, have all filed independent lawsuits against a variety of oil companies, claiming that the oil companies' activities on the coastlands have led to land loss. So some of the barges and other things and some of the activities there have caused land loss that is exacerbating environmental harm, and that these folks should be liable for it. And they have a variety of unique, novel theories that are being touted now. These are perfectly lawful. These were perfectly lawful activities that have been going on for decades, all the way back to World War II. Some of these lawsuits reach when really what was happening with the oil companies, they were creating aviation fuel for our fighters in World War II. This was stuff which was encouraged by the federal government, encouraged by the state government, consumed by the state and federal governments, consumed by the, without anyone objecting, and in fact, with much encouragement across decades. And all of a sudden now we want to impose retroactive liability to say that these activities, these commercial activities that were lawful and permitted, nonetheless, you should now be liable for them. And a verdict came down just last month in the Plaque Mines Parish case, which held Chevron liable for $745 million in environmental harm for activities dating back decades. And it's all based on this 1978 law, which in and of itself, the law, the State and Local Coastal Resource Management Act, I have to look at it sometimes to remember all the words. But that law said, if you don't have a permit from 1980 forward, then you're going to be liable for some harm.
Yeah,
you're gonna be liable to people because you need to get a permit. So it was because before that, these kinds of activities didn't require permits.
Sure.
If it was before 1980, then you're basically grandfathered in.
Right.
Well, they're trying to use the tort system to ignore that and just ignore these the grandfathering, and to claim that these companies should be liable for these things. So I'm happy to talk more about it, but it's the latest way in which we see municipalities trying to find a way to fund their underfunded budgets by seeking out deep pockets.
So, it's funny. I remember many years ago, maybe when I was still doing work with defenders, but maybe after, there was that we were starting to see the push for so-called environmental justice. And there was a lot of discussion about what was happening down along the Louisiana coast, the Alabama coast, et cetera, and the harms that could be caused. And I pointed out that we're looking at it in a very one-dimensional way. The environmental justice folks were looking at it in a very one-dimensional way because they were looking at, the risk of X, Y, and Z without looking at the benefits, right, of better jobs and the economic activity that's down there. A lot of this, I think, was blunted at the time, but it seems like we're back to this. And once again, I point out the but for, right? What would these communities be looking like? Now, sure, they might have been very much like, for many years, the area south of Tallahassee, Florida, along the coast that was all owned by the St. Joe Paper Company, where it was untouched and unspoiled, but there was no economic activity happening. There was no benefit to anybody. Sure, you might have all kinds of land that's sort of wilderness. Then maybe there's value in that. But on the other hand, also there are jobs that are being provided. I mean, is anybody talking about the benefits that have been created down in these communities by this economic activity being there, the standard of living and the lives that have been elevated because of this?
Yeah, I think there are some who are challenging these lawsuits that certainly are making that point. Unfortunately, the Attorney General's office is not supporting supporting these cases. So they're not making those arguments on behalf of the citizens.
No, of course not.
That's problematic. But you're absolutely right. This is why litigation is a really poor vehicle for a lot of things, because it can't consider trade-offs. It has a claim based on harms, but it can't say, oh yes, but those harms came with all these these benefits, and they can't do cost benefit analysis most of the time.
Sure, right.
And so litigation is not what litigation was designed to do, to set
Right.
policy, and that's for the legislatures to do, and to take into account the benefits of an activity and understand the trade-offs or the opportunity costs that are associated with this.
Right.
And one of the big problems, not only with the incapacity of the courts to do this, but the second problem is that once you start imposing retroactive liability in these cases, then that kind of investment never would have happened in the first place. In other words, if you told people that they're going to be on the hook for everything that they're doing here, and even though it's been permitted, that's chills investment. And just having courts start to recognize retroactive liability chills prospective investment, because I'm not going to go to Louisiana if I think that and invest in communities if I think that 30 years from now, because norms have changed or because tastes have changed, I'm now going to have to pay things that I did not put in my business plan.
Well, it gets back into exactly what we started talking about at the beginning, the concept of reasonable investment-backed expectations and the issue of hope and prosperity, right? The stability issues, right? It essentially, because what you're talking about is the retroactive application or the retroactive punishment, it undermines the rule of law, doesn't it? It creates a perverse distrust in all of this. Talk a little bit more about that.
Sure. The entire idea of prospective lawmaking in the rule of law is designed so that people can adjust their behavior according to their assessment of their potential risks of liabilities. And so we do it that way, and we announce, and there needs to be fair notice, and people can adjust their behavior and determine what the costs of their actions are going to be, so that they can build that in. And it's just simply unfair to say that you did something lawful, which we encouraged, which we in fact told you was fine, and now sometime later in the future we're going to change our mind. That's not what the due process clause is about. It's not what fair notice is about. And so it has not only the sort of policy implications, but it has real constitutional problems.
And this gets back into also why we talk about the issue and why it's a misnomer to talk about the takings clause as a sort of a separate entity, because the two go hand in hand. The issue of due process and the issue of the takings, nor shall private property be taken for public use without just compensation, right? Folks seem to forget that the due process elements are an essential element of the property rights aspect of this, right? You need to be able to have the notice that the property is going to be taken, and you need to have an ability to argue why the property shouldn't be taken. And so many of the property rights cases that have been out there over the years have been about the issue of due process. We worked on a case out in Monterey, California, where the city of Pacific Grove made it clear that they were never gonna let this guy use his property. They were never gonna let him build a house, and so there's no due process, right? I mean, if you already know it's stacked against you, and it's like, okay, fine, if you're gonna do that, then you're gonna just give that to me. But let's talk about other perverse incentivization that goes along with this. You testified just about a year ago. In fact, when we release this, it'll be just about a year ago. You testified up in Congress about third-party litigation financing and the issue of intellectual property. Talk about that issue, because I've also find that fascinating.
Sure. So increasingly lawsuits, particularly those that, plaintiffs' attorneys are bringing, are being funded by third-party litigation funding.
Yeah.
And it is a secret enterprise because currently only a few courts actually require disclosure of this money being involved. And so the idea, though, is that you're investing in the hope of a return on the investment from the judgments in these cases.
Right.
So it is not about at all the merits of the cases, but instead it's about the expected return, which is also the expected settlement return from leverage that happens in all these cases. And it creates all these problems in which the the funders are interested in creating new causes of action. They're interested in creating advertisement campaigns which gin up get everyone excited to file lawsuits,
Right.
even though they don't have any harm, because the idea is to make it so heavy on the defendants that they're going to be settling, and then they can take a cut of the settlement. And so third-party litigation funding is not, it is masked by the advocates as an access to justice. It helps people get into court in the first place, but that's not how it's operating in practice. We have contingency fees already. We have ways that people can fund this. Third-party litigation started in Australia where there were no contingency fees. So this was seen as a way to help people get into court. It's here it is truly a market, and it's becoming really, really sophisticated in which there's bundling now of cases, there's portfolio financing. One of the big problems about portfolio financing, by the way, is that, think about this. If you have a portfolio of stocks, you don't pay attention to too many of them because you can always shift around, you can sell, et cetera. So you don't have a large interest in monitoring. Diversification of your risk occurs, right? So these funders that have portfolios aren't investing in figuring out what the highest quality cases are. They're just funding a bunch of stuff, knowing that they can hedge the bad cases against the ones that are, like, I wouldn't even call them good cases, but cases that are likely to lead to money
payoff.
And so there's arguments that it won't increase meritless litigation. It indeed will, because you're more likely to invest without actually screening what you're investing in.
Right. I mean, again, and you put it in with what we've been talking about in Louisiana, right? Not that I'm saying that these third parties have invested in things like that, but it really creates a mess out there. I had someone ask me to sign on to a letter. I signed on to it just the other day, but they were talking about the issue of foreign actors, getting involved in foreign corporations, and is that part of the problem here as well?
It is, and I didn't get to the IP issue when you asked before, but it's particularly a problem in the IP space, because what you have is you have foreign competitors who are actually using the litigation to drive up the cost of doing business of domestic IP firms, essentially, right? So it's not even, some of the litigation is strategic, and they're funding the litigation just to cause problems or disrupt their competitors. And that's a real problem. We should expect that, and we've seen this now, the funders will tell us that there is no foreign funding in, but then, what we discover is that there are a lot of things that funders will say doesn't exist, like that they don't have control over the litigation. Then we find out that, oh, yes, actually they do, because we're not allowed to see the contracts. The courts are hardly ever asking for to know if funding's even there. But in the IP space in particular, we're getting, that foreign competitor issue. And in all across the board, there's an interest in others funding litigation to get around sanctions, for example. So there's a bunch of Russian oligarchs who have gotten into the foreign financing, and this was exposed in a Bloomberg article. You've got sovereign wealth funds who are investing in this, and all the people who do recognize that there is an interest in destabilizing our institutions from others, from a geopolitical strategic standpoint, should understand that a destabilization of our judiciary should be a prime target for any clever adversary. And so if they're allowed to start funding and they get to do it behind a veil of secrecy, why not? And so it's something which is trickling out, but again, because we don't have a robust disclosure regime, there's some legislation to try to fix that. That's as what I was testifying. That we don't have a robust disclosure regime means we don't know what we don't know, and I dare say that we can predict what we don't know, and what we can predict is not very. Is a little scary.
I didn't ask you, and I should have, just to turn our attention back to Louisiana. What are the next steps? Where are things going to go? What do you see happening?
So the Plaquemine Parish case will be appealed, and there will be so there's a question of, whether or not the appeals courts within Louisiana will ultimately recognize some of the meritorious defenses that were not recognized at the trial level. And then the other 42 cases are going to perk along. And unfortunately, with the momentum of the success in this recent case,
Sure.
I suspect a couple of things are going to happen. First off, they're going to be even more eager to press those cases forward. But the second is that, the defendants, I don't have any insight on this. I'm not involved in any of this, but anytime you see a judgment against someone that big, it does change your settlement, considerations. So, unfortunately, a lot of companies see these high liability risks and say, I've got to cave, and hopefully they'll have the gumption to get some contrary precedent out.
Does this require some kind of federal legislative fix, or is it going to take a Supreme Court decision? What's the remedy here?
I think there will be some questions whether or not these cases are preempted, whether or not things like the assertion of authority in the EOs should make a difference. So we have the Unleashing American Energy EO. We have the EO on protecting American energy from state overreach. So I'll be curious to see how the administration tries to use the assertion of those powers that they have in those EOs as a way to try to influence what's happening down there. I don't have any specific playbook how that will work out, but there are ways in which I think the Congress can also come in and try and preempt some of these lawsuits directly, or otherwise, put a stop to these. And I think that the state itself could decide, this is detrimental to our state. And so the state of Louisiana could, despite the fact that they've signed an agreement, I don't think that they can sign away their duties to protect the citizens of the state. So they signed an agreement not to actually challenge these cases, a joint litigation agreement. But I don't see how a state official can actually delegate away or sign away their fiduciary duties to protect the citizens of the state. And these are dangerous to the overall consumers in the state.
100%. I'm just sort of thinking in my head how I might write a letter or two, or send a comment into an agency. So let me ask you this before we let you go. My listeners have heard me say this before. I always like to talk to my guests about the stuff that they do that isn't directly related to their work. I almost had done a podcast. I'm doing 3 podcasts nowadays. Nobody should do 3 podcasts. But I almost added a podcast that I was going to call Outside Interests. The idea being that, I was talking to I'll throw his name under the bus, Larry Spywak at the Phoenix Center, for instance. They do great work on telecom policy and law and economics. Larry plays a harmonica in a blues band. And there are other folks that I've talked to. So when you're not doing this kind of work, Donald, how do you spend your time? What are some of your outside interests?
So aside from hiking and things like, actual physical activities, I used to restore a lot of furniture, but we've now completed our house with most things. And if I do any new project, it has to be replaced by others. So I've kind of shifted to restoring frames. But this is because in part, it is related to my work, because I was doing work on linguistic framing. Okay. And I got very interested in literal framing.
Okay. Interesting.
And so you can see some of it behind me now, but I find, old frames that need some TLC, get them into better shape and match them with better art than they had in them before. So
fascinating.
So much of my house now, we live on Capitol Hill in an 1892 row house, and most of the art is now in period authentic frames.
Nice. So you commute the opposite way. You go from Capitol Hill out to Arlington.
I do. Yes. It's 37 minutes door to door on the Metro.
Well, how do folks find out more about the good work you are doing?
So they can visit my, the GMU website where my bio is, and there's a link to my SSRN page. Or you can just type in Donald Kochan, Kochan, SSRN, and that lists all my scholarship, including some of the things that we've talked about today, including the forthcoming article on involuntary regulatory servitudes. You can read the near complete or near published version draft of that piece, which should be out this fall.
Love it. Love it. Love it. Love it. Well, Professor Donald Kochan, thank you so very much for joining us today.
Thanks for having me. This has been fun.
Our guest has been Donald Kochan. He's professor of law at the Antonin Scalia School of Law at George Mason University. He's the executive director of the Law and Economics Center. This has been, as I said, yet another episode of The Lunch Hour with Federal Newswire. Check us out on our YouTube channel. If you're watching us there, you know you can take us wherever you want to go on the many fine podcast platforms on which you can find us: Spotify, Apple Podcasts, Amazon, et cetera, et cetera, et cetera. Tell your friends and family members all about it. Please subscribe, leave a like, leave a comment. I am your host. I'm Andrew Langer. Thank you very much for joining us today. Enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream.